Welcome back, ladies and gentlemen. We will move to the second part of the event, the colloquium. The first session, the Constitution, the Judiciary, and Democracy, will be chaired by Mr. N. Ram, Director of the Hindu Publishing Group. The key speakers for the session are Justice K. Chandru, retired Judge, Madras High Court, and Justice K. Kannan, retired Judge, Punjab and Haryana High Court. I would request Ishita Singh to honor Justice K. Chandru. And I also call upon Rosebud to honor Justice K. Kannan. And now, a few words by the way of introducing our speakers. Justice K. Chandru, as we all know, was enrolled as an advocate during 1976 and was designated as a senior advocate during 1997. He was appointed as the judge of the Madras High Court in 2006 and retired in March 2013. He has authored several books in Tamil and English and written numerous articles for newspapers and journals. Among his books is My Judgment in the Light of Ambedkar, published in Tamil and then in English, dealing with cases relating to caste and religion dealt by him as a judge. Another notable work is about cases relating to gender, titled Listen to My Case. As a judge, he has disposed 96,000 cases, which might be a record. He has also been in the limelight recently for the film Jai Bhim, made last year by director T.J. Gnanavel, in which the star Surya played his character. He was awarded the Dr. Ambedkar Award for 2021 by the Tamil Nadu government. Justice K. Kannan is a senior advocate and mediator and was formerly judge of the Punjab and Haryana High Court and chairman of the Railway Claims Tribunal at the Principal Bench at New Delhi. His domain expertise in mediation is a highlight of his track record. He helped set up a mediation center under the aegis of the Tamil Nadu District Legal Aid Authority at a village near Kadalur, a first in such a rural context. He was awarded the Weinstein JAMS Fellowship in 2017, which enabled him to further his interest in mediation and to hone his mediation skills. He has authored and also edited many books on law. Over to Mr. N. Ram to chair the session.
This session is titled The Constitution, the Judiciary and Democracy. And we've had three outstanding judges. Let's not be under the impression that they are typical representatives of the higher judiciary in India. They are outstanding representatives, each. I was also listening carefully, I can say along with Justice Chalameshwar, about how he would be introduced. And we took a virtual bet. Would the press conference be highlighted or his judgments? And I think the introducer did a fine job of balancing the two. And we already heard what you need to hear about his outstanding contribution. He retired as J1, after the Chief Justice, the senior most judge, and we know some of the cases. But I also want to highlight the importance of that press conference, even though he perhaps wouldn't like that to be overemphasized, but I think it's equally important for the independence of the judiciary when the situation becomes unacceptable or perhaps even intolerable. Even judges who usually maintain silence outside the court on what's happening came out for the press conference, and for those judges who came out and educated the country on the strange things happening in the Supreme Court under the aegis of the master of the rolls, I think, of the roster, master of the roster. I think That is a fine contribution as well. That's my opinion. Today we are discussing a very broad subject, and each of them will speak to what they consider important. Justice Chandru I've known for a long time from his student days, and we have been friends for many years. And I was surprised when he was appointed judge of the High Court, given his views, not because he was enormously talented as a lawyer, erudite, interested in theory and so on, but the fact that he was appointed despite people knowing his views, I think, is a tribute to that in particular decision or induction. Justice Kannan, we've heard about him. He practiced in Kadalur. He's come up in a different way, an extremely erudite judge who, as has just been mentioned, has, among other things, of course, adjudication came first, but also mediation. I just want to make a few comments. I don't want to take too much time. We have about 1 hour and 50 minutes for this session, minus what we have taken away for the introductory part. But I think in this book by COLLOQUIUM Raj, I think there is a section on courts, and those interested in this particular theme of this session, I think would do well to go through it. It's a very critical set of articles on the performance of the high courts, but not all of them negative by any means. I think they are well reasoned, and the principal question, which was formulated after a discussion with Justice Chandru and also Justice Kannan, but it was Justice Chandru who suggested this as a theme, as a description, as a blurb, if you like, for this session, and I'll just read it out. We are under a constitution, but the constitution is what the judges say it is. And this was a famous statement made by Justice Charles Evans Hughes in the US Supreme Court. And then the second part of that formal statement is, and the judiciary is the safeguard of our liberty, he also says, and property in that particular court, under the Constitution. Is the judiciary as a whole, and in particular the higher judiciary, living up to this challenge that we are under a constitution, but the constitution is what the judges say it is? That may be a bit of an exaggeration, but captures, I think, a large part of the essence, perhaps, of the situation in India. And the judiciary is the safeguard, that's the key part, of our liberty under the constitution. We've already heard from Justice Chalameshwar where we are. There have been a number of criticisms I've read recently about the performance, not just of the subordinate judiciary, but the higher judiciary, the Supreme Court in particular. Scholars like lawyers and scholars like Gautam Bhatia have termed it under certain chief justices as an executive court. It's become an executive court because in this aggression launched by the executive branch, particularly the branch headquartered in the center, but also in some other states, when there's an assault on basic rights and freedoms, what is the performance of the judiciary? That is one set of questions that arises, not the sole question. And why is the judiciary in a position where it is unable to grant relief or render justice to citizens who are outrageously attacked? Mohammed Zubair, for example, or Tista Setalwad, those in the Bhima Koregaon case. And in COLLOQUIUM Raj goes into specifics in this set of articles under that theme, the courts, where he is very critical. There is also, he cites case law from other countries, including the United States, but primarily we are concerned with India. How independent is our judiciary? All the three judges who are here have been known for their independence. They were also erudite. Of course, their integrity was never in question. They were also efficient, given the caseload. But how independent has the judiciary been historically? That's one set of questions, but more recently. And I think the track record would be probably very mixed. It's probably an exaggeration to term the higher judiciary as having been transformed into an executive court, but isn't there a large measure of truth in it, particularly in the current situation? But there have also been, in the past, as has been mentioned earlier, dark chapters in the history of our judiciary when it comes to safeguarding our liberty. And this is, I think, a theme that will figure. There are various other aspects. I don't want to preempt the approach of each of our distinguished speakers. They will have enough time to set forth their views and offer their, in effect, their assessment of how the judiciary has performed in relation to democracy and the Constitution. And may I invite Justice K. Chandru, former judge of the Madras High Court and a frequent writer. Both of them write for the press, all of them write, are public speakers also, to give us his remarks.
Dear friends and comrades, Vanakkam. In this session, you will find three names shown there: Ram, myself, Kannan. Then we have Justice Chalameswar, we have Shashi Kumar, then Indira's husband Chandrasekhar. All of us, we have one common thread. We were all alumni of Loyola College, a college run by Jesuit, and that is something, a link all of us have today. Why I mentioned about the institution of Jesuits in Madras, it's because when the Constitutional Assembly was convened, there was hardly any representation for the minorities. And therefore, the Assembly nominated Father Jerome D'Souza, a Jesuit member of the college, as a member of the Constituent Assembly. The Constitution, fortunately, because there were some stray representation for the Christian minorities and other minorities, it also had a provision, a specific provision for the right of the minorities under Article 29 and 30. Therefore, when the Constitution was drafted, they also thought about minorities, and there was a nomination, though, because they may not get elected, and therefore there was a nomination. And very curiously, a Jesuit father was also nominated as a member. And this Article 30, wherein minorities have a right to establish an educational institution of their choice, right to conserve their own language, and there are rights which have been incorporated in the Constitution, which you will see how much it came for attention by the court. The largest bench of the Supreme Court have always upheld this as a sacrosanct right, that the right of the minorities are inalienable. It is sacrosanct and nobody can touch it. It is not susceptible for any interference. Therefore, the first half of the constitutional history of India, the judges did bestow their attention to say this right can't be touched. Now you see the second half. Very curiously, the Supreme Court now start thinking whether Hindus are minorities in this country. The right was created for something as a reason. Now the Supreme Court has given notice to see what should be the unit, whether state is a unit. Maybe state is a unit for a language. But in respect of religion, do you think Hindu religion is a minority in this country? And now the Supreme Court is hearing. Therefore, you will see a very significant shift in the approach of the court in seeing some of the fundamental constitutional issues. I will start with that, with this note. The first time when the Union Jack was lowered and the tricolor was made to unfurl on the ramparts of Red Fort, Pandit Jawaharlal Nehru made a historic speech which Shashi Kumar was referring to. He said, when India is asleep to freedom, when minority is sleeping, we will be awake to receive the independence of this country. According to many, the whole world is asleep and we are awaking. But one thing is that when that incident took place, the communists of this country were kept in jail. They were not allowed to participate. Why I begin with a note? Because it is in 1947, whether both left and right were in jail. The RSS was proscribed, they were also in jail. Therefore, we start from 1947. There were two approaches to the very same problem, namely the path that this country will take, the position that this country will go forward. And when the communists were in jail, they were publicly condemned, their detention. In fact, Mr. A.K. Gopalan, one of the leading Marxist leader later, then communist leader, undisputed communist leader of Kerala, he wrote in his biography, "The British never detained us. It is the so-called independent India which has detained us." The whole night I was awake, looking outside what's going to happen when the dawn of 14th night disappears and 15th is born. We were anxious to look forward for a new country. Therefore, this was the heart feeling expressed by the communists who were in jail, and the RSS never said anything word about this transformation. Therefore, from that day, you can see two different shifts in the approach to this problem. And in 1947, after this democracy or the new country was taken over by the Congress, they saw to it that every time they will start excluding any leftists from them. According to them, they have a suzerainty over everything, and therefore the Constituent Assembly did not have any good representation from the left. It had the princely state, it had the nominated members, it had many zamindars, it had also had the elected representatives, but did not have any specific, because they were all in jail. And why were they excluded? In fact, Dr. Ambedkar, after the final draft of the Constitution was prepared, he was the chairman of the drafting committee, and after 2.5 years of debate, the resolution was introduced in the Assembly on 26 November 1949. He made a very historic speech. I think all of you should read the speech. You can see it in the website. In the internet, you can see the speech. In one of the portion, he says why the leftists were not allowed. He says that they do not believe in democracy. They believed in armed overthrow of the state, and therefore they have no. And I do not mind that people may have their own views, but this country is wedded to democracy, and therefore only those who believe in peaceful transition of this country alone will have a say. In his speech, he says all that. Now, what is the position of communists? Now, in 1949, when this draft was approved, and India was about to become a democratic, socialist, sovereign republic, elections were to be held under the new dispensation. And in that dispensation, the first elections were held in 1952. Before the elections were held, the communists were still rotting in jail, and it was the communists who started showing not the Red Book, but the Constitution of India to the court. The first two major constitutional cases came to the court from the communists. The first was by A.K. Gopalan, who approached the court and told that I have been under detention without any trial. I have not been accused of any particular charges. If your constitution believes right of expression, right to liberty, right to legal protection of equality, then why I should be kept inside? This was the first question raised before the Supreme Court of India as the first constitutional question. Therefore, the communists started waving not Red Book, but the Constitution itself. So the loyalty, the faith which the Constitution makers made the people to believe was also being attempted to use in the court by the communists. Unfortunately, A.K. Gopalan case, which was argued brilliantly by M.K. Nambiar, one of the leading barristers, later followed by Mr. A.S.R. Chari, the Constitution petition was dismissed. The Supreme Court said that all the rights, the Charter of Rights given under the Part 3 of the Constitution, namely the fundamental right, has to be put under some compartment. You can't read one article into other. Gopalan asked the question, if I have a right to expression, where will I express? Not in the central jail in Madras or in Kannur jail. I'll have to express myself. If you think I can move throughout the territory of India, then why is that I am confined to Madras Central Jail? This is a very pertinent question because each fundamental right takes color from other article and each has to be seen as a bundle of rights. It's a charter of rights. This argument was rejected by a 4:1 majority by the Supreme Court. Supreme Court said each article will be seen only in an individual context. You are a detainee. Just look at Article 22 and be silent. You have been detained by a competent authority. We will not go into any other issue. Now this is fine. Because the judges at that time felt for them the integrity of India, the safety of India, and the safety from the communists of India are more important. Therefore, the first mistake, we'll say the constitutional mistake was made in 1950 in A.K. Gopalan's case, which did not last forever. After 20 years of the judgment, a time came whether A.K. Gopalan was rightly decided or not. And finally, Supreme Court, not in a case of a detainee, not in a case of a revolutionary, but in a case of Tatas and Birlas, where the banks were nationalized. 14 private banks were nationalized by Mrs. Gandhi in 1969, and that was challenged by the Tatas and Birlas and other bank owners. And in that case, the Supreme Court felt that the right to property cannot be seen in isolation. It has to be seen in the light of other, including equality under Article 14, and therefore it became a bundle of right, a charter of right, and not individual right. What stood before them to decide? It is A.K. Gopalan's case, and therefore A.K. Gopalan's case was overruled subsequently after a period of 20 years. Why it was overruled? Not because they had love for freedom of expression or freedom to speak whatever they want. It is because they want to protect the proprietarial right of the Birlas and Tatas. I am not saying this. Even the then Law Minister Shiva Shankar told that this court is meant for rich people, property people. The proletariat has to be stand outside. And the right of the proprietariat was recognized in a right of a proletariat case. And therefore, the proletariat case, which stood for 20 years against the people of this country, was removed. And nationalization was struck down. Mrs. Gandhi went back to the parliament, amended the constitution Article 24th Amendment. It was once again challenged, but then slowly it got changed and they upheld the amendment. And therefore the shift in the approach of the judges also started taking place from 1970. From 20 years, there was a very conservative approach on many issues, not only this issue, 101 issues I can talk about. And I'm not going to take much time because Brother Kannan will take a portion of this subject, and therefore I'll only confine to the right to liberty and right to expression as to how the Constitution saw it and how the judges saw the whole issue in the same context. Now, in that context, I also deliberately want to bring up the role of the communists in shaping this Constitution, or at least the challenges they faced in facing the democratically elected government. Therefore, Constitution as vis-a-vis the judges is one of the very important subjects. As Ram said, it is not what is written in the Constitution, it is what the judges say. And therefore it assumes a greater importance because it is not the written words. It is not something like a scripture. It is what the judges speak. They don't speak through oracle, they speak from their experience. One small example I can tell you before I begin. I want to tell you there is one issue which is keep coming, which is even haunting all of us. You'll see this you know what's a straw. This straw is made of paper. This straw, what is made of paper straw, this paper is also known as parchment. And Justice Krishna Iyer, who is always like to frame new phraseology in the legal language, he coined a new word. He called the Constitution as a pachydermic parchment. Parchment is a paper, pachydermic is an elephant. Because it's the mother of all laws. Constitution is the mother of all laws. And therefore he called pachydermic parchment. Now this parchment paper, which the Constitution is today is there, and the straw, what is the relationship between the straw and the Constitution? This also came up for test. Recently in Bombay High Court, Father Stan Swami, one of the Jesuit priests who worked among the youth in Jharkhand, he was detained under UPA, kept in Arthur Road Jail in Bombay, and he had a Parkinson's disease. He's an 84-year-old man, and much of his youth was spent in the tribal places in Jharkhand. His Parkinson's disease could not allow him to hold a glass of water and sip. It is shaking. It has to spoil all his clothes. Therefore, he wrote to the prison authorities that let me have a sipper. Prison authorities, what they do immediately, what the bureaucracy in this country do, look into the rule book, saw the prison rule, found there is no place for a sipper in the rule. They said, sorry, we can't give. The rules do not permit. The rules may not permit many times. As always, Chalamesar said, it's not what is written to the Constitution. It's the inalienable rights are there, and therefore this could have been solved by the bureaucrats. And when the bureaucrats fail, you come to the court. And he went to the Bombay High Court. Bombay High Court judge, they asked. They said just a sipper is enough to drink water. Then naturally, any judge for that matter, any judge with some human concern, any judge with the constitutional spirit, any judge with the human spirit would have said, give that sipper. If there is no budgetary fund, in fact, this does not even cost when you go and ask for a coconut water or a fruit juice, the shopwala gives you free. Suppose the judge, prison says there is no budget. Then you could have just said, many times we have done in our court, some girl comes, I have no money to pay, they are demanding huge fee. We ask many lawyers to contribute. This could have been done. On the other hand, the Bombay High Court ordered notice whether there is a right to receive a sipper or not. By the time the Arthur Road Jail got hundreds of parcels of sipper sent in favor of Stan Swami, but unfortunately Swami is not more with us. He died for lack of medical attention. And that is where, between this paper sipper and this parchment, the elephant parchment, there is a conflict today. And it is mainly the role of judges that we'll have to think of before we discuss any other issue. There is a parliament, there are elected representatives, there is an elected people's representative, they have many discussions, many amendments. And as Supreme Court has said, the Constitution can be amended several times. It has been also amended. It's not, as I said, scripture, but whenever the constitutional question came to court, how did the Supreme Court look at the issue is the most important. When the communist ban was removed, the communists decided to participate in the election. They did not believe before, but they decided we will serve the people in whatever way, and this is the way of serving. We will also have a constitutional path. And therefore, in the first elections in Madras presidency, which is almost like the entire South India, the communists, along with Sri Prakasam, got the highest number of seats, and Congress came second as the single largest party. Now, who will be the governor will invite? Because they have poor in mathematics, and therefore they invited Congress and not the communist-led government. Not even as an experiment, whether it is a floor majority or it is a majority outside, or so many questions have come later. But the first question came before the court that they invited the Congress party, which did not have the majority on the floor of the House. Now the Congress party elected Mr. Rajagopalachari, the Governor General of India, who chose to become a chief minister of the state. In fact, once when Rajaji was asked to hold some post as a governor or some other place, he wrote to Nehru that the only post I did not hold is a Tahsildar and RDO. All other posts I have held. So from Governor General, he became a chief minister here. How did he become a chief minister? He did not contest in the election. He is not an MLA. Then how did he get elected? He was nominated to the Legislative Council, the upper house. The upper house was not constituted in 52, but the governor yet nominated him as a MLC. Through backdoor, he became leader of the Congress party. And then there is no majority. How will they form majority? There were two caste-based parties, Commonwealth Party and Toilers Welfare Party, two parties of the one-year caste group, which was the largest caste segment in the northern Tamil Nadu. Each had some sufficient MLA posts. Each of them were offered some minister posts. So the Ayaram-Gayaram politics started in 1952, not because of the cherishing democracy, but to contain the communists. And for that, the bureaucracy is ready, the central government is ready. What about the court? The famous Chief Justice Rajamannar, sitting with the bench, and P. Ramamurthy, the leader of the Marxist Party, filed a writ petition before the Madras High Court, saying that how is that you are nominating somebody who is not even an elected member? How is that the governor is not even inviting the majority group and only a largest party? And his petition was dismissed, saying Ramamurthy does not have a locus standi to come to court. He was the leader of the Communist Party, which is the largest segment in the assembly, but the court ruled, we will not give locus standi for Ramamurthy to question this. This is the first experiment which the communists felt at the time. You raised a constitutional question and you are non-suited in a judiciary. And this is how the constitution, you can see twist and turn in the constitution. In 1957, when the new Kerala state was formed, the communists stood in the election and won the elections. E.M.S. Namboodiripad became the chief minister of the first Kerala government. He formed the government. An elected government has a right to make laws, and one of the important laws which they made as soon as they came to power was the mushrooming growth of educational institutions, which was having no regulation for it worth its name. From the British period from 1935 till 1957, all these rules, the schools, colleges, were all controlled by some administrative rules. Therefore, the first Kerala educational bill was introduced in the Kerala Assembly. And as expected, the Congress, being so opportunist, started a big campaign against this bill. The bill was to regulate private educational institutions so that the teachers are paid, the salaries are regulated, the fee is regulated, the students are given proper certificates. This was the outline of this. Now, when this bill was introduced, there are several stages. The bill has to become an act, the governor has to give an assent, and since it is a matter concerning other issues, it has to be sent to the president, and president may also agree to give a consent. And thereafter, there is a Kerala High Court, there is a Supreme Court, you can challenge all that. But then, nobody wants to go to a constitutional path. They took to the streets, and therefore the Christian minorities and the Muslim minorities, the Nayars and the Eravas, led by the Congress Party, started a Vimochana Samaram to dislodge an elected government. Waiting for their opportunity, Pandit Jawaharlal Nehru sent his daughter, who was then Minister for Information, to Kerala to see how this Vimochana Samaram, the liberation struggle, liberation from what? Liberation from the communists. An elected government of the run by the communists has to be thrown out. Now that government was dismissed in 1959. Within 2 years, when the newspapers were writing the first ever democratically elected Communist Party ruling in a state, in a southern part of the state, it is gone in 2 years' time. For what reason? Because there was agitation against some of the reform that was being brought by them. Now there was no court to question whether the president's action in dismissing a lawfully elected government can be questioned or not. For a long time, the judiciary always felt that these are all political issues, we will never interfere. There are not justiciability. These are not issues to be brought to court. This position continued for quite some time, nearly for 40 years. The courts were said, hands off. You dismiss any government, we are not going to. Until the Bommai case, where the Supreme Court by a larger bench ruled, that is also justiciable. That is all the court can see. You saw recently, when the Pakistan Prime Minister was unseated, within one day, the Supreme Court restored the government. The law is different today. Likewise, our own Supreme Court took long time to learn. There is very little thing about the politics, or even if there is politics, it has to be seen in the correct light. I will tell you, before I go to other issues, that Constitution being a political document, it was brought by a political structure. It also established a political democracy. Every issue in the Constitution is a political question. Therefore, when the Supreme Court or any other High Court says, I will not touch it, is something which they wrongly trying to say, or they're trying to support the status quo. And therefore, when the communists were thrown out from Kerala, there was one thing which survived. the bill brought by them, the Kerala Education Bill, the governor of Kerala has to say it has to be given assent or not. On the contrary, the then central government took a very curious step of referring this for a presidential opinion, asked the president to send it to the Supreme Court under Article 131. There's a law passed by the state, not tested by court, but then it is sent to the presidential opinion to the Supreme Court. For the first time, Article 131 was used to destabilize a government's proposal. Now, what did the Supreme Court do in that opinion? They upheld the law. The law was upheld, but the government has gone. Most ironical thing that took place when the court said this bill is valid. They also used a very important cliche, important statement that the right to administer an educational institution will not amount to maladministration. So this is what everybody was trying to do. And thereafter, many states have made several laws which can cut inroads into several educational institutions, several spheres of education, several control measures were brought in, several regulatory measures were brought in, but the communists were lost. The first elected communists were lost. They did not give up. They again stood in election and got elected. That is most important. In 1967, after 10 years, one election later, the same EMS government was installed in Kerala. The people of Kerala voted for the government. And very important issue, this is more ideological. Why I am saying was, the ideological battle before the court, whether it is in the name of court case, whether in the name of constitution, is always being taken root. Now, EMS Namboodiripad gave a press statement in 1969, facing the Thiruvananthapuram press reporters. He told the press that the economic sphere will have a more superior force, and the judiciary can never rise above the economic structure of this country. This is a Marxian statement, that no judiciary can rise above the level of economic structure. Ultimately, what is the dominant force is the economic structure of this country. Then somebody filed a contempt that an elected chief minister is trying to denigrate the judiciary. Nobody can denigrate the judiciary, except they can denigrate themselves. Now, the Kerala High Court found Namboodiripad was guilty of contempt. So they punished him with 1,000 rupees fine. Under the law, you can punish up to 2,000, but the judges felt 1,000 rupees all right. He went to Supreme Court, thinking that Supreme Court will interfere, because it's a Marxist concept of a state, that the judiciary cannot rise above an economic structure is a Marxist concept. But unfortunately, Justice Hidayatullah, hearing that contempt case, held that EMS Namboodiripad doesn't know Marxism. Nowhere Marx said anything like this. So what he did was, he dismissed the contempt petition, but however he said EMS Namboodiripad salary at the time for chief minister is only 150 rupees, therefore reduce the fine to 50 rupees, from 1,000 to 50 rupees. Now, when judiciary writes a judgment in Namboodiripad case, you can read the judgment also. Para after para, they are quoting certain political statement, trying to say that Namboodiripad did not know Marxism. Now, this is something like an open debate. All this happened in 1970s. Many of you would not have been born at the time. But the debate did not stop with that. Mr. Basav Punnaya, who was a Politburo member of the Marxist Party, wrote an article in the People's Democracy saying that the judges doesn't know Marxism. And he quoted para from the economic and political manuscripts of Karl Marx to say that how Namboodiripad has correctly made a statement. And there is nothing like his not knowing Marxism. But then the judges didn't want to continue this debate, and therefore they are very happy with punishing a sitting chief minister. Why I am saying this particular aspect was that the judiciary at points of time take a very animus stand on any left ideology and never supported a stand which is a possible stand. And you see from then onwards, you saw they were mentioning about emergency, and Chalameser also mentioned, hundreds of thousands of people were detained, and what happened? The detention orders were challenged in many high court. Some of the high court, at least 8 high courts said that we will look into this issue, but then all these cases were transferred to Delhi, and very unfortunate, one black day of the Supreme Court came, they dismissed all the habeas corpus petitions and said, it is not open to you to come to court when fundamental rights are suspended. Very, very shocking position where nobody will ever support the ADM Jabalpur. Now, ADM Jabalpur judgment rendered in 1978 is a judgment rendered by judges interpreting the very same constitution to say that if the sitting government suspends your right, you can't come to court. Access to justice, access to court has always been considered as one of the cherished rights of any Indian citizen. If I am wrong, I can go and complain. Now the court itself shuts its door, putting the executive order as a door, closing the door. Now how long this took to say that this is a wrong judgment? People can come to court, and today they can come to court. But the court did not want to hear. And therefore, I am only trying to impress upon you to say that every point of time when there was a strain, when there is an extraordinary situation, when system is trying to be perverted, contrary to the constitutional norms, the court always sided on the wrong side and not on the right side. The judges of the High Court who tried to issue habeas corpus were all transferred out. Justice Chinnappa Reddy went to Punjab and Haryana. Justice Chari went to Assam. There are judges who are, merely because they were part of the bench, they were all transferred. Now the transfer is one issue where the judges are afraid, therefore you try to say status quo is better. To be on the safe side, try to support status quo. Try to support the power of the government. Don't take an opposite stand. This is something which you can see consistently in the matter of liberty. It's always, I can go on speak because there is a lack of time, I'll only say a few things. Now the question of bail. Everybody talks about pre-trial protection to the citizens. Now one Justice Kaul now recently said, we must have a bail act. Everybody is praising. All you see, every newspaper writes an editorial praising this suggestion. What is this big suggestion? I want to know. In 1893, Criminal Procedure Code provide for a bail, followed by 1973, 438, Section 438 provide for bail, 439 added, because Law Commission recommended, why should somebody get arrested? Even before arrest, there is an anticipatory bail, pre-arrest bail. There are two provisions. Now, hundreds of judgments are there all over. It's not something new. Is it a question that there is no bail available today? Or the judges don't think they should not grant bail? Even if you bring a new legislation, what is the guarantee that it will be recognized in your favor? You see the case of Kapan, who is a journalist. They rejected bail. Today there are 12 individuals. One has gone out of 13, 12 individuals, out of which 11 are still there for 3 years. Where is the bail? Is the UPA doesn't have a bail provision? The TADA had a no bail provision, or POTA had a no bail provision? Merely because you call it as terrorist law, does it mean there is no bail? In fact, we argued the case of POTA detainees in Madras High Court. And we said there is always a bail under criminal law, right from the days of the federal court, which said that if there is no prima facie case, no person can be detained. Therefore, there is always an inherent right to get bail. The question is whether you want to grant bail or not, or you use the bail. In fact, one of the judges said, Justice Ramana, who said that in this country there is only a pre-trial detention is enough. Nobody goes through the full trial, and therefore people are all happy with the pre-trial. And he also went and said that there has been so many under trials who are inside, not the convicts. The government should take steps to release all these prisoners. Even if you grant bail, there are majority in this country cannot come out because lack of money, lack of complying with the surety condition, lack of engaging good lawyers. Therefore, it's not just a question of having provision. As rightly said, the law goads the rich and grinds the poor. Therefore, you can have any provision for that matter. You can talk about bail act, you can talk about releasing the prisoners. Even the Sustainable Goal Development of the United Nations Assembly says that there are so many people are under trials, and you should also try to deal with that, because it is not in our rule of law, it is not in our criminal justice administration to keep somebody in jail without trial. You got to have some trial. And now you make new laws. Apart from the regular existing criminal law, you feel that it is terrorism. Why? Even money laundering now, some judges said it is a terrorist law. Money laundering is worse than terrorism. So what is the lesson that you draw? You say that every power to the executive, the enforcement directorate. Now this is something which is new, where when slowly the legal development or the lawmaking exercise in this country goes in a direction, instead of stopping this kind of excessive power on the part of the bureaucracy, you now try to give some slow pontification of justification of these laws. Now, therefore, you will find today a person can be detained without FIR. Why? Because there is an enforcement directorate information report. That is not FIR. Then what about arrest? Enforcement directorate asking some people to come is not arrest. Therefore, we can be detained. The opposition leader in this country can be asked to come 101 times before the enforcement directorate. Which court will interfere? I want to know. Where did the judiciary go in these matters? In fact, somebody wrote a judgment that terrorism, money laundering is also terrorism. I agree. Every white-collar offense, we also feel that of late, only poor people are caught in some of the IPC offenses. There are more increased white-collar crime, therefore that should be contained. All that is true. But then, what about rule of law? What about the minimum human rights standard? You call somebody urban Naxal. Word is very beautifully coined. 12 people are inside. And Sudha Bharadwaj got bail. Not because she's a MIT graduate or a well-known person, but because there was a mistake done by the judges. The judge who remanded her, he is not a special court, but he was only an acting additional session judge. On a technical point, she has come out. What about the others? 3 years. All right, bail is not there. What is the charge against them? Last 3 years, there is no charge. If CRPC is applied, 90 days bail, default bail, 60 days bail, default bail. But if CRPC is exempted, indefinitely you can keep people inside and you put a label, urban Naxal. What is this Naxal? We do not know. In fact, I remember Justice Chennappa Reddy, one of the finest jurists in this country, in his Prem Shankar Shukla's case, he wrote, some people call them bloodthirsty monsters, others call them as Joan of Arc. It all depends on one's own hue. Short of saying, well, your own class background decide who is an accused. That is the state of affairs we are occurring. Who reduced this state of affairs? That is the main question that we come into, and therefore I will finish this because some questions will be there, and Justice Kannan will also follow. Whether it is a question of expression, that is another big story. The Supreme Court, the first ever judgment, they said, 19(1)(a) right to expression. What ordinary citizen will have, the press also will have only that right. Somebody said in America they have a greater right. They said we are not America. So the dividing line is very clear. All right, if dividing line is very clear, now recently, the American Supreme Court, in the Roe versus Wade, the abortion case, they held in the first American Constitution, there is no provision of life and other things. Therefore, they said struck down. After 50 years, they removed that Roe and Wade decision. Now, if you start saying that the Constitution is what it is written in 1950, first you are denying its own dynamic growth. You are also making it look like a scripture. In Bangladesh, if you denigrate a constitution, under Article 7A of the Bangladesh Constitution, you can be given life sentence, you can be given death sentence for denigrating the Constitution of Bangladesh. Fortunately, we don't have provision. Maybe in Kerala, that Shaji Cherian was thrown out. He said something about, in fact, he did not say anything contrary to the Marxist position of state. He only said this constitution is meant for the rich and the landed gentry. Nothing wrong. But then the party expelled him. In fact, I wrote an article in Hindu also, saying how wrong it is that this constitution provides us to a mechanism to criticize the constitution. because it's a growing document, it's an organic document. It is the wishes of the people who decide the very shape of the Constitution. 108 times it has been amended, not something new, but still we start saying something new in this country. If you think this Constitution is sacrosanct, then some of the constitutional provisions have been removed. Article 370 was a basic provision of this Constitution, giving a special status to Jammu and Kashmir. Now that is just removed. Therefore, now that question that is raised in the Supreme Court is not answered. 3 years have gone. They travel everywhere. One judge goes to London, another judge goes to New York, another judge goes to Russia, address meetings in St. Petersburg about the various things, about the great things about this country. Justice Dhananjay Chandra was asked by the London School of Economics that how is that the minorities in this country are not protected. Then he, a good judge, I will not say more about him, but I will say one thing. He said, some of these cases are pending before me, I can't answer. Our Chief Justice went and told the Americans that we only swear by the Constitution. Sir, what about your judgments? No, we'll see. I have appointed my successor now, and he will take care of it. So now we find, for every world outside, we have a very beautiful structure, beautiful institutions, one of the largest democracy with the highest power in the Supreme Court. In the world, if you challenge, the highest power, the maximum power is with the Indian Supreme Court. Given a letter card, they can treat and undo many things in this country, but they are not opening the mouth. Whether it is a case of Jammu and Kashmir, or whether it's a case of Citizenship Act, or any important issue in this country, just keeping quiet is enough. Somebody asked me, even Ranjan Gogoi, after his retirement, got an MP post. He wrote a biography in answer to many of these criticisms. Very curiously, he gave a title, Justice for the Judge, as if that is lacking in this country. Now that is there. Some TV anchor asked him, sir, can you deny there is no corruption in this country? He said, I will not deny. This is a confession coming from a highest person of the Indian judiciary. I also say corruption does not mean only cash for orders. Even denying important issues, denying sensitive issues of any hearing to which it decides, to which it requires, that is also corruption. And therefore, I will only conclude temporarily today that when you talk about Constitution, we have also seen it is a very dynamic document. The growth of the Constitution, at many times they were also interpreted in a very progressive manner. We can speak pages after pages. But my question is, when a fundamental question of constitutional interpretation came, the judiciary either kept silent or did not decide the matter. Thank you.
Good afternoon. To do your job worthy of talking when you follow Chandru, it's always a handicap. So, of what he was able to do with such facile ease, I may probably be now and then looking at my pad to say what I should be saying. Levitsky and Ziblatt, they have written a book, How Democracies Die. This is what they have to say. Democracies now die. Blatant dictatorship in the form of fascism, communism, or military rule has disappeared. Across much of the world, military coups and other violent seizures of power are rare. Many countries hold regular elections. Democracies still die. But by different means, since the end of the Cold War, most democratic breakdowns have been caused by generals and soldiers, but not by generals and soldiers, but by elected governments themselves. Like Chavez of Venezuela, elected leaders have subverted democratic institutions in Georgia, in Hungary, in Nicaragua, in Peru, the Philippines, Poland, Russia, Sri Lanka, Turkey, Ukraine, Thank God the authors did not name India there. Probably it was written at the time of the heydays of Trump, and they were truly concerned and worried about what was happening in US. What kind of democracy are we having? What kind of subversion is taking place? That was the concern for the authors at the time. So they said, democratic backsliding today begins at the ballot box. Many government efforts to subvert democracy are legal, in the sense that they are approved by the legislature or accepted by courts. Now, I start with this because that is a challenge which we are facing today. Do we have a democracy? And what do we understand? And is it possible that we are missing something? In fact, in a survey which was done in Venezuela, where they found on a scale of 1 to 10, where 1 is not at all democratic and 10 is completely democratic, the people were asked to give the responses on what do they enjoy in their country. And surprisingly, 52% of the people said that they are fully living in a democratic setup. So therefore, that the people are confused. Am I living in a democracy or not? And if they are all deluded to think that this is how democracy is run, where the rights can be taken away by the government, they can impose anything they want, they can take any person in imprisonment. If all these things will happen, and we'll say, all right, courts will take time to dispose of, that is fine. Bail is denied now for the person. In fact, a particular judgment of what Brother Chandru was talking about, where there has been a judgment of the Supreme Court, exceedingly sensitive, all the same, by Sundaresh and by Sanjay Kishan Kaul and Sundaresh. He talked about protocol, about how to name judges in the order of seniority at all times. So it's exceedingly well-drafted judgment, if you'll see, and talks about how bail is the rule and jail is the exception. All lofty expressions where you will not take any person or deny to any person a bail for not normal offenses. Normal economic offenses, you will let them. But only if there is a matter concerning national interest or security, that is when probably it has to be denied. You will have to apply stricter norms. All in a concern that there are, our jails are occupied, there are 130% occupancy there, and therefore we need to find methods of relaxing this issues, the reasons for incarceration, and then give them bail. You have all those things done, but now, today, if there is something which I want to settle against you, be it a landlord-tenant dispute or a small amount of not being paid, you will find rights have to be protected. You will not deny a right of freedom of movement or expression, but then you will have still a problem. You have a judge taking note of what is now done in a Twitter. Now they say that the judges don't now any longer express opinions. They merely say some 250 characters. That is what is 250 characters for Twitter. They'll make the statements in quote to that number. What they will say, they will not be able to put in writing. And all that must go into a Twitter. Or even if they don't see Twitter, there will be a person who will be, the court will be offended by what it sees, what somebody puts in something in Twitter. Now, a sensitive judiciary is all right, but how sensitive we are to our own, to any person showing any finger at you, if you are going to be exceedingly sensitive about contempt of what, if a chief minister says something, where a person says that it's a class that determines the kind of judges that we have, you have contempt taken. If you say that judges are corrupt or the higher courts are corrupt, you immediately, are we saying, and if there was a former Chief Justice of India who was saying, yes, there is corruption in judiciary, and if somebody says that also, they're corrupt, and you will immediately take action. This is the kind of judiciary where, right, so several maybe. So therefore, this is seriously an issue. And then the common belief to many of us, particularly of those who are trained in law, or persons like me, we believe that having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and having a non-political method of choosing the judges, in the sense that you don't contest an election, or you don't, like what happens in US, where that's also a political appointment. where you are called to explain your own stand, your political ideology, your views on things, all that is all put to question. Nothing like that is made, and therefore we believe judges are neutral, that they are capable of distancing themselves from immediate, intimate emotions and then look beyond things. But then we have held faith that the Supreme Court will be the sentinel of the QB, and the democracy is surely assured. But there are several factors that lend to the vibrancy or weakness of democracy. I'll make no attempt to examine all the features, but I will begin with what Ambedkar said would be the test for what democracy is. I'm taking it literally from where Justice Chandru started, and to that is seriously a concern now in this present dispensation of governance and the way the courts look at it. Ambedkar said, there is only one thing which I think is very necessary in the working of democracy. And it is, in that name of democracy, there must be no tyranny of the majority over minority. The minority must always feel safe that although the majority is carrying on the government, the morality is not being hurt, or the minority is not being hit below the belt. Predictably, I'm going to be talking about Article 29 and 30, which deal with the protection of minorities and the right to establish institutions. And then in the context of we are talking about minorities, again, we are talking essentially of religious minorities. Linguistic minorities do not have any problem of being subjugated somewhere or they're losing their identity. But now we are going to treat some class of persons as second class, and who will be denied rights which are not denied to others, and then you think that is the way to live, then I think there is something very serious. Therefore, when I'm talking about Article 25, 26, it says the freedom to manage religious affairs, to establish and maintain institutions of religions and charitable purposes, to manage its own affairs in matters of religion, to own and acquire movable and immovable property, to administer such property in accordance with law. Now, in a book by Fallinariman, India's legal system, Can It Be Saved? He said this: armed with a written constitution, our proud boast in India is that we are a nation governed by laws and not men and women. But this is only theory. The law is ultimately what the judges in the highest courts say it. In fact, this is what is the Hughes statement of what Ram started with and where this topic has come about. He records in his book something extraordinary of perhaps arguably one of the most talked about case, the case that secured certain features in the constitution as basic which could not be amended in Keshavananda Bharati, which dealt with the 24, 26, 29 amendment, and which contained provisions relating to property, to what extent it could be abridged, what can be removed, the test of several provisions in amendment, where the amendability of the constitution itself was the point in question. There, the judges, the Fallinariman notes that there was such amount of disrespect and a kind of suspicion of one against the other, they did not even see each other. In fact, he records there, the case presented such a sorry spectacle that the bench of 13 justices who could not agree only because they would not agree to what the majority had said. And the final order which is found ultimately in a Supreme Court reporter, it did not come anywhere else. It was signed only by 9 judges and 4 judges refused to sign because they did not agree to what was ultimately there. The 7-6 difference is also a judgment where you don't have all judges signing. So that is the kind of, there were occasions at the time when the judgment was being written and when it was reserved for judgment, where a judge will not meet the other in his eye. That's what he records there. And this is an institution which has to bring about judgments in cohesion. And then Justice Chalameshwar was saying it's a court of 2 judges. No, when 13 also when they sit, there is a problem. So the larger numbers don't make anything better. The fact is that imperil the strength of democracy now from the context of our treatment of minorities spring from the downslide in the way we have brought about some legislation from public perception and above all judicial pronouncements. I'll keep aside the public perception of what goes on in the minds of people, of the majority community people, or the right, I wouldn't say majority, or about how the laws have come about in some ways which are exceedingly questionable, that which subverts the protection to minorities. But I look at what the Supreme Court has done, and that is the only attempt which I'm going to do now. Supreme Court in its early years and in initial years, they had been exceedingly protective. In fact, some of the pronouncements of what you will see, if I would note, it was the Anglo-Indian schools to admit persons of non-Anglo-Indians and still maintain the minority character, and they could impart only English as the medium of education. Could it be done, was the question. And the Supreme Court said they had the right. They have a right to administer. They have a right to even say how the medium of instruction shall be. And if they say the medium of instruction shall be English, it shall be English. No question that there are also students of the non-Anglo-Indian community that could still make such an important statement, because they were interested in seeing that their own right to be protected in the manner of establishing an institution must be full in its sense. And about the same time, at another case, to striking down several of the provisions in the Kerala Education Bill in 1959 in its advisory jurisdiction, where there was, it was perceived to be a takeover by the Communist Party-led government of the Christian schools. And that was the apprehension at the time. Justice S.R. Das, in his concluding version of what he would say, look at this. The genius of India has been able to find unity in diversity by assimilating the best of all creeds and cultures. Our Constitution, accordingly, recognizes our sacred obligation to the minorities. In 1974, that was a judgment which was delivered in the year 1959, and in the year 1974, when the Gujarat University Act of 1949 gave the university a right to recruit, when this was brought in challenge in St. Xavier's College, where they said it was a serious infraction in the right to administer educational institutions, the 9-member bench affirmed the conclusions in the Kerala Education Bill in that case. And the particular interest of what would obtain to me is what H.R. Khanna said. H.R. Khanna had a manner of saying things which others would not think. And he was thinking for the future at all times. And he said, the safeguards of the interests of the minorities amongst the sections of the population are as important as the protection of the interest amongst individuals, or persons who are below the age of majority or otherwise suffering from some kind of infirmity. The Constitution and the laws made by civilized nations, therefore, generally contain provisions for the protection of those interests. It can indeed be said that an index of the level of civilization and Catholicity of a nation as to how far their minorities feel secure and are not subject to any discrimination or suppression. That was the yardstick. That was the touchstone on which you will gauge whether the country is being governed in ways which are appropriate, which is democratic truly. Where does the slide literally begin? I was looking through some of those decisions of what was upholding the rights in Kerala Education Bill, or probably the earlier decision, Anglo-Indian School, or probably the St. Xavier's College case. Probably I may not find immediate takers or persons who would support me, but I see TMA Pi begins the downslide. TMA Pi in 2002, which was decided, the Supreme Court adopted an interpretation which was less favorable. They were trying to see the right to establish under Article 30 through the lens of Article 19. The right to, you are seeing that as a particular kind of administration right to establish something. And if there are profiteering happening, then there could be restrictions, and that restriction can impinge on even your right under Article 30. This, I think, putting Article 30 without referring to it as an independent right, of a fundamental right to establish, to be seen through the prism of Article 19 is a major flaw, in my view. And that was the starting point of where you see the slide. And P.A. Inamdar, which these are all names, legally trained persons who love to hear all the case names, but then not so for others. But I'm just telling you, these are important milestones of our own constitutional history, and therefore just get those names. Inamdar literally approved this, and in modern dental college it went more. A constitution bench resolved the different views of various high courts, and to hold that the state could provide for uniform single entrance test for prescribing minimum standards of admission into professional colleges, and that would include minority institutions. And there it was stated that the fundamental right, in fact, Nariman makes a strong reference about this in one of his articles, or probably in a speech, I don't know where he said the fundamental right of the minority education institutions have gotten therefore devalued, because approximating the provisions of Article 30 to the provisions contained in Article 19(1)(g) was truly wrong. I will not go so much into it, but there are other concerns of what I have, like what the author today is talking about, constitutional concerns. Now look at what we have done in other areas as well. All the while, the efforts of converted Christians to get SC status, they have not succeeded. The battle was waged even in 1950. Sikhs and Buddhists have, over a period of time, they have somehow obtained the the legislative nod. They have been able to secure their own inclusion into the scheduled caste status. And there is a writ petition which was filed, a Center for Public Interest Litigation through the General Secretary and Franklin Caesar from Tamil Nadu is the person. Our own concern, I have not noticed at all times that it's so, when I've spoken to the Punjab University students in an auditorium like this, understanding reservation was the topic which I had taken to speak. They will never understand that there could be social justice and reservation is a matter which constitutionally is recognized and therefore it has to be supported. We'll find unusually persons who will question, how will that happen? Where is the merit? As though reservation is something to do with merit. I'm not straying away, but to give to a point certain aspects of what take place in the north, how they look at it. This writ petition which has gone from south, from Tamil Nadu. If I sound parochial, allow me that benefit. Franklin Caesar is the person who has filed the writ petition. This was filed in 2004 under Article 32 of the Constitution, challenging para 4 of Article 341 of the Constitution relating to the Scheduled Caste Order of 1950. More than a dozen individuals have also joined. From 2004, the Supreme Court is not able to find time to take that case. In fact, Justice Chandru has written a judgment about how unfair it is not to give to them the status of scheduled caste. How will it be correct of persons who suffer from social exclusion, regardless of where they have moved by the change of faith, has not really meant anything. But then the Supreme Court does not find time to dispose of this case. In fact, the Mishra Commission, which was appointed to consider that, it was a direction which was issued in that case itself, in the case which was filed in the year 2004. The Mishra Commission has given its report, and they consider the identification of socially and economically backward sections among the religious and linguistic minorities, and they have suggested several things. They said 10% quota for Muslims and 5% for the minorities in government jobs and seats, reservation up to 8.4% out of the existing OBC quota in the quota of 27% for minorities. SC reservation to Dalit converts must be given. All these are recommendations which are still not seen the light of the day. And then these are issues of how the slide has happened, how it is getting deepened, of matters of importance of what the court must be doing that we are not able to find time to take it is a matter of great concern or worry. Now, the recent aberration. Recent aberration comes through a bench. The case is still there going in a district court in Varanasi, but I'm still saying this is a bench of Chandrachud. My friend Chandru immediately said, a good judge, I wouldn't say anything. I'll say something, nothing extraordinary, but all the same. Justice Chandrachud and Chandrachud is a Harvard law scholar, became a judge in one of the earliest, less than 40 he was when he was picked up as a judge. Suryakant is again another judge who I have been a colleague at some point of time in Punjab. Suryakant is again a very, he was probably the youngest Advocate General in India at 37 or some 36 or 37 became an Advocate General, bright man. Narasimha, again, a person who was picked up from the bar. Therefore, you assume persons who come directly from the bar. This is some kind of a class which we practice. That persons drawn from the bar are better than persons who come from the services right from the place down. But then these are three persons who constitute a bench. Look at a simple thing. What is brought before is somebody finds something like a shivling. Let's assume it's even a shivling. And what was stated to be probably a fountain somewhere there in a pond. And someone says about 5 women joined together and file a suit saying that this is shivling there, we must have a right of worship, and therefore a suit is filed. When the institution of the suit, there was also an appointment of a commissioner, the report gets leaked. I will not go into those details, but I'll give you some glimpse of what the legal issue is and how the court is tottering. The point was, this act, there was a Places of Worship Act of 1991, brought at the time of this Babari, the Ram Janmabhoomi issue, when the heydays of problem of what can happen. And the Narasimha Rao government at the time thought to ensure cohesion in the community and bring about harmony. This is the object and reason which is given. I'm not giving the exact words, it was something similar to that. And the act says, the act for the preservation of ancient and historical monuments and archaeological sites. No, it says the dispute of, it only talks about section 3, just allow me that benefit. Bar of conversion, it says, no person shall convert any place of worship of any religious denomination or any section thereof into a place of worship of a different section of the same denomination or of a different religion. So therefore, section 3 contemplates a complete bar of converting any place of worship of a particular deity to any other form of any other denomination. If there is a mosque where there is a worship which is offered for Muslims, there is no way you'll be able to bring it. If it was at the time of 1947, it was like that, no change can happen. They only brought about exceptions. Exception was the Babri case itself because that was there in court and therefore they did not bring about a lot to modify. But then it was very clear that you won't be able to modify is what they said. No doubt, no ambiguity. Section 3 is so clear. It provides for some exemptions. That exemption is like a Babri case itself. Another thing of what they say is, if there is an institution or there is a place of worship which comes under the ancient monuments and archaeological sites of Act of 1958, I was looking into those provisions. It is very clear in respect of those ancient monuments which were declared to be so under 1951 Act. 1951 Act, if you go, those institutions which are set out in the schedule below, you don't have, to my knowledge, I don't see this place as declared to be an ancient monument under 1951 schedule. And it could have been an open and shut situation where the Supreme Court could have very easily said there is suit cannot go any longer. But then you have the Supreme Court saying in a cryptic language, ascertainment of religious character is not barred by section 3. Do you see any difference from what I said? Section 3 I read to you, no person shall convert any place of worship. That is what is barred. Now, the Supreme Court's interpretation, ascertainment of the religious character is not barred. What are we going to be now seeing? The religious character of what? Religious character, if it is a Muslim worship, if it was used for that, it cannot be changed, is what section 3 says. The exemptions I told you, it does not, the Ancient Monuments Act is not there. And the court makes an interpretation and makes the scales even in the situation. In fact, making the scales even is a wrong thing. The Punjab court has an emblem which is very different, not a blinded Queen of Justice holding it, the scales even. On the other hand, it's operates on a different thing, on a scale which has different weights. Weight which is bigger one on the side, the smaller on the other side. Where you provide the fulcrum taken, you need to bring it closer to the place where it is the more weight. The idea is you provide a long arm to a weak person to beat the person with, or to get the scales even. Now, that is how the court must be. In cases where minority interests are concerned, it needs to you need to go and see, is it correct? Is the approach correct? If you don't take that and I say, it's the majority feel like that. Court decisions are never majoritarian. If a court ought to be concerned and if all decisions must be made of what the majority like, we don't require courts. If the court decision in Sabarimala must be made only on the basis of what the majority of people in Kerala ask, I don't know what the majority would say. But then if that is what is going to be the concern, you're not going to be interpreting Constitution, you're going to be misinterpreting Constitution. That's a dangerous thing to do. The court decision to see what the people want is not the way the courts work. But we need to be sensitive to what is necessary for the society, because law is an instrument of social engineering. We need to obtain something. What are those? They're very clear. If we must see what our Constitution preamble says, we understand what we want. I read out to you what we secured to ourselves through the Constitution. That must be the yardstick which the court must at all times see, and therefore we have learned persons going to the courts. When I'm talking about the Supreme Court, it's not the only court which matters. We have if the language of the Supreme Court is not good enough, or if their approach to things is not fair enough, things are bound to be worse. And that is the reason why you have a magistrate who will not look at a person through the window and say everything is all right. The policeman says, all right, all right. Why would he care for what the Basu case says? He will not say, because the Supreme Court also does not see. They don't have time. Now, it may seem like taking exceedingly views which are cynical, but then our speaker, the author of the book today was said, there is a certain pessimism about my book, but the need is for us. I rather wish that it was all not true. Me too. I also wish some true. I'll therefore raise some questions and then I'll conclude my speak. These are probably rhetorical, or if they are not rhetorical, if they seek answers, you'll find the answers yourself. My questions are this. With this, I'll conclude. Will it be appropriate to examine the conditions of minorities only through the minimum aperture set through the dwindling efficacy of Article 29 and 30, without examining the social realities of what exists, where there is so much of unemployment, the status of minorities is not good enough? Is minority protection available only through the so-called appeasement politics of political parties and considering them as vote banks? Will that be a fair way of looking at it? Did the Constitution provide adequate safeguards in restricting SC status only to Hindus and relegating Dalit converts to OBC status? Is that fair? Is the change in demographic pattern of high rate of population growth among Muslims as index of increased happiness, or a calculated design to extract new privileges, or mere symptoms of illiteracy and fear of applying family planning devices? What really is true? What is the cause? And look at what the law we have made. There is also probably a reference in this book of what I see of criminalizing triple talaq and the Sharia Banu case. Should it only be seen as a personal law reform, or a patronizing piece of legislative condescension? What do we see as the resultant thing? Are we not practicing duplicity when we say the Citizenship Amendment Act, or what I did not come to, probably that's a speech in itself, does not aim at Indian Muslims already living here? How do you see them as second-class citizens? Is that fair? See, these are matters. In fact, the social reality of what you will say, like I said, the Sachar committee shows what is the economic status of these persons. And I have read an exceedingly sensitive book of Mothering a Muslim Child by Nazia Iram. It's so sensitive. You worry about how so many parents complain. She has made some empirical study of examining some of the parents where they say the child is not invited to, a child, Nazia, does not get invited by Prakash's mother to a birthday party. The child says, no, why am I not invited? Then the next day, when the mother occurs that, Prakash, I believe there was a happy birthday for him. So wish him a congratulations. Why was Nazia not invited? Say, we invited only Hindus. Now, this is what you bring to your child. And that book, Nazia Iram, talk about mothering a Muslim child, how difficult it is. If a common educated person, now you're not talking about even persons who are illiterate, think about illiterates also, but then if they feel excluded, and if they think that they are not they are not seen at par equal, and our courts and legislation bring about that kind of a situation, have we a matter to be truly worried? With this, when I say a concluding thought, now I will only say there are utterances that the term Hindu does not represent a religion, but a geographical entity of persons who are living within certain areas. If that is true, if you are only identifying Hindus as persons living within a particular geographic entity, should it not be by a logic also mean that just like Ram, Allah and Jesus must also be our gods, all of them there within the area, all of them, those Hindus must pray to that also. We do not see any movement developing a homogeneous class of citizens in India, of all persons belonging to one world or one country. That has still not happened. We still have probably a long way to go from the base mentality of epitomizing the unique characteristics of some persons, of some communities, and to fight and subjugate them. There is no text more sacred to us, to all of us, than the Constitution and what ideals they spell out. The high ideals of what the Constitution give will have to be worked only through us, subordinating our own majoritarian propensities to muzzle dissent and differences. Democracy is not what the majority wants. It is to walk with the minority hand in hand with equal pride in oneness of spirit. Palkiwala said, and with that I'll end, the Constitution was meant to impart such a momentum to the living spirit of the rule of law that democracy and civil liberty may survive in India beyond our own times and in the days when our place will know us no more. Thank you, friends.
Yes, now we've had two erudite presentations, observations based on their experience, their learnings, and also their moral being, raising questions. So we have some time for this discussion. I invite comments, but only on the area that is been allotted to this session, namely the role and performance of the judiciary in relation to the Constitution and democracy. There's also been some questioning of, what the Constitution is, a discussion on that. It's dynamic, Chandru said. Chandru also went back in history and found a certain continuity to the problems that we face. Justice Kannan raised a number of other questions, particularly towards the end, and gave illustrations. So questions, comments, as brief as possible are welcome.
My name is Paneer Selvan. I'm a former editor of the Hindu. My question is about electoral bonds. Why are the courts completely silent about this issue? We're talking about constitution, judiciary, and democracy. And electoral bonds seems to be the central issue.
Electoral bonds. Why is the judiciary silent on this? Would you like to take it?
Why is the Supreme Court silent on electoral bonds? Why is the Supreme Court silent on Article 370 and its abrogation? Why is the Supreme Court silent on matters of immense importance like finding when a person can be taken in and how long can a person be incarcerated? Why is the Supreme Court silent on several issues of vital importance which ought to govern? That is what has been the problem. Electoral bonds, you don't want my bhashan on electoral bonds, I'm sure. That is not what your question was. Why is not the Supreme Court doing? The problem has been that it may sound too harsh. We all find comfort in taking a class of decisions which we are familiar with, where we don't want to confront too many tricky issues or too many issues which are sensitive. If I am dealing with a case relating to a government servant who is dismissed from service or who has been demoted, or where there are class of persons who complain of some larger interests of some environmental issue, they are not less important, but it's all very easy to handle. It's less difficult to handle. When we're talking about electoral bonds, we are talking about who are we trying to protect and who we should protect. Who are those persons who are taking extraordinary benefit, who flood, who secure a whole lot of resources from people, from establishments, big institutions, and then use them for electoral purposes? Everyone understands. Who spends more money at the election? Everyone understands. How many times? 10 times what BJP spends is to any other party. Do we care? Would I not be asking, when I'm talking about electoral bonds, where this money is coming from? Who am I literally be targeting? Now, these are the issues, ultimately. These are realities. So therefore, the Supreme Court will not take up issues which are in some sense sensitive, and that's not happening. And we need a leadership. Like we all say, if there is a lion for a leader to asses, lion will win against a leader who has a donkey for a pack of lions. Who will win? The lion as a leader will win. The leaders determine the institutions. I'm not denigrating judiciary if I say the Supreme Court is not taking up matters. We require a leader who would do. I'm just expecting something good to happen in another 3 or 4 months. I think that's what will decide on what important issues will be taken. And this could be taken up. They have identified this subject, this case, as something which must be taken up immediately. It has not happened. The same way as 370, they said the bench will be constituted. They sounded big, but it has not happened. This will happen, I hope.
Chandru, want to add on anything? Thank you.
I have a question to Justice Kannan.
Introduce yourself.
Yeah, my name is Krishna. So I have a question with Justice Kannan. Sir, is protecting a minority means that the taking away the rights of majority and don't see any problem with majority? For example, why the government controls only the majority temple, Hindu temples? Why the government loot Hindu temples, right? Why there are more than 8 to 9 states in India where Hindus are minority, right? Why don't we have same principles for that? For example, take the example Jammu Kashmir, where Hindus are an endangered minority, right? Already face a genocide, right? It's protecting a minorities mean that it's neglecting everything of majority, and say majority don't have any issues, majority don't have any problem, majority don't have any issues.
Yeah. Thank you, Krishna. This was your question was asked to V.K. R.V. Rao, who's a statistician of eminence, probably Oxford or Cambridge scholar. And he wanted to come back to India. The question was, why do you want to go back to India? He said, who would a mother care in her house? She has love for all children. If there is a sick child, will she be more attached to the child or not? If my country is sick, will I go back to my country or will I revel in this kind of opulence? That was his answer. Now, in any situation, a number, a numerical strength. Let me confess to you on something. Chandru and I had office in Lingichetty Street. There are churnings in our mind at several times which improve us or which makes us look at things. Lingichetty Street is predominantly owned by several persons, Bora Muslims and other persons. During the Ramzan time, at 6 o'clock, when they break the fast, that road will be simply, the whole lot of people, it'll all be those white cap Muslims, a lot of them standing there, breaking the fast and taking something. At 7 o'clock, at 6:30, when I would see that kind of number, suddenly it used to, I'm now making a confession, it kind of get rattled. Oh my, there's so many of them. That they were others and I was different was an issue for me. You must know that a minority has that complex at all times. That a sheer numerical strength of a majority could be overwhelming. So when we talked about protection, any country only talk about protection of minorities. There is nothing like protection of majority because you take by default minorities require protection. You don't talk about majorities requiring protection. On the other hand, you referred to the equality principle of what must visit all our attempts or laws. So therefore, when you're saying that if a genocide happened in Kashmir, do I have an issue that they should not be protected or they should be sent home, they will not be rehabilitated? There are larger issues in Kashmir which we are not tuned to that. The way we are keeping Kashmir, is it worthwhile that way? Is that the self-determination principle which must operate? What is the constitutional status of Kashmir? Did we do something recently on 5th August 2018 in ways which should not have happened? These are political questions. I wouldn't try to take that question now. But there is no doubt that the majority minority must be seen from a national perspective. And that is what just now our friend Chandru said. Sikhs are minorities in Punjab. Would you believe there is a judgment like that? And there was a division bench who said, no, they can't be seen like that. The state of Punjab has Sikhs are the majority people, and therefore to use the minority protection, because they have minority protection laws. There is one particular judgment, can you believe? This is by a 3-member bench of a person who was later a Chief Justice of India, who wrote, the judgment will begin with a flourish. This case, 161-page judgment. This case we heard from morning through evening for several days together. The persons who argued were just not the lawyers in my court, but persons who are engaging in communication through email from Canada to England to Australia. All these people wrote. For what? There was the minority use of minority for them enabled them to set up a committee which will decide if there is a woman who seeks admission to a medical college run by a minority institution, whether she tweezes her hair or not, her eyebrow. For a man, whether he clips his beard or not. If he clipped, he is not a Sikh. If she has tweezed her eyebrow, she is not a Muslim, is not a Sikh. And the court said, these persons, there is a girl who came to court saying now, I tweezed my eyebrow and I was called to appear before a committee. The committee examined me and said, have you used a clip? I said, yes, and therefore I've been rejected. And they were saying, no, this is correct. A 3-member, a full bench of Punjab court. This case has been now from 2008. 150 pages. 161 pages of eminence. And that case is still there in the Supreme Court. It has not been decided. So minority status to be taken like that, for depending on 8 states, they'll be like that. It'll be wrong, friend. That is not the way we'll understand. Because there is a freedom of movement. People migrate from one place to another. You can't particularize a person in that state as constituting a minority, and therefore they'll be treated as that. We all talk about a unified India. We talk about an India which is vibrant. And majority community requires all protections. Where is the doubt? We don't talk about protection through law. We take that as available at all times. We ensure all rights are protected. That's what the majority community enjoys, all your part 3. And still, if we still have some problems, there's a problem which will handle it differently.
The question is not protecting something. The question is, today you come to a situation where you cannot have a procrastination or delay deciding matters. I've been traveling in Karnataka last 3 months extensively. This question of hijab, and later halal and azan. Question of hijab, 20,000 girls have not written their examination. Does the Karnataka High Court just sleep over the matter? Or the Supreme Court, hearing the SLP, can decide anything they want? What happened to those girls? Is it a question of exclusion or a question of inclusiveness? Now, that is the issue, not anything else.
Myself, J. Ramakrishna from Communist Party of India, Marxist. Justice Chandru or Justice Kannan referred to Ambedkar's last speech in the Constituent Assembly. Dr. Ambedkar also said, however good a constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad law. If good people arrange the governance, constitution will survive. If the bad people comes to power, constitution will not survive. This is what Ambedkar's last speech, he referred. Now I believe, in my view, the four fundamental pillars of the Constitution, secular democracy, federalism, social justice, sovereignty, are under attack. Why can the highest judiciary in the country protect the Constitution? Judges like Syed Ahmed, a dissenting judge in Allahabad High Court during the British regime, and also Supreme Court judge like H.R. Khanna. Why can the highest judiciary in the country come to the rescue of the Constitution?
The persons that write judgments are persons who believe they're protecting the Constitution. Do you think any of those judges who say the view which does not satisfy you, they are against the Constitution? They swear by the Constitution. There's no doubt about that. But we have vitiated the atmosphere so much that the right thinking does not go. The higher principles do not emerge between them. They want to say something which will capture the persons who are in the corridor taking down some notes and who are going to publish the next day.
TRP rating.
The TRP rating, the UMS, whatever we say. So therefore, if only the judges write opinions and not merely quips, that's what I said. We make 52 characters, 250 characters, that's what I'm interested in making, and people take notice of. So therefore, there are, see again, in my view, so many persons, when they arrive in the Supreme Court, meaning no disrespect to Justice Chalmeshwar, something goes into them, something which upsets a balance in some way. I may seem like saying something which is not very popular, but then I've known a close friend, probably, of who denies bail to Kappan. I wouldn't believe that it is ever possible. This Kappan goes from Delhi to a place with his camera, probably he's a photojournalist, and then Hathras victim, what had happened, what really caused her death was what he was trying to say. He's picked up, and for so many days, he's just still being kept inside. There is a denial of bail. New evidence is brought every time something new is stated by saying that he is detained not merely for some offense there, going there. His presence outside will be a threat to national security. And then you pass on some documents, then put it in a sealed cover and give it to a court. And the other person does not know what really is going into the reckoning of a judge when he is denying it. We have a new jurisprudence of a sealed cover jurisprudence which has come about. The Supreme Court has said they will examine that issue. They are not examining it so far, to my knowledge. They secure more sealed covers to incarcerate people. Why does the Supreme Court behave the way it does? There is a lot of hope. It's not so much to despair. There are brilliant judges there. But something happens when you go to the Supreme Court. So therefore, that they must know that they still belong to the people, that it's such a high institution because it is for the people that they exist. That realization. The manner of choice of judges also plays an important role. If only we have 55 judges. If we have 10 Chandrus, what would have made it? Would it not have made a difference? That's not happening. Where does all the talent come from? The talent comes from the bar. The judges are picked from the bar. The moment you go, till the previous day, a normal person of what you see outside, the moment he goes, judges are corrupt, you issue a notice of contempt. Has not something gone wrong with the person who does that? That position makes it so. Unfortunately, that's what happens. That they must all be grounded, that they must believe that they are dispensing justice for the people. They exist for the people. Unless that feeling is consciously and periodically and consistently cultivated, it can go wrong. So it requires probably big leaders. If there was one settled word was as a lawyer sufficient to discipline the whole of judges. That is what Krishna has said. One settled word could make a difference. We require men of eminence, just not in the judiciary. From the bar, if you have persons of sterling character who can stand up to a judge and say, what you're doing is not correct, then it will not go wrong. We don't have persons of that eminence. We don't have persons of that moral authority to stand up and say, you're wrong. That is the problem. It happened now, fortunately for us, in the Supreme Court, when the Attorney General got up and said, now what you're doing, you're trying to pass some orders and then give some directions to the Supreme Court to do in a way. You don't have a power to do. The High Court is equal to you in every other way except in some matters. Then we'll examine that matter. They put it for examination of that matter, whether the Supreme Court can give guidelines to High Court to do something. Not in an order or appeal where you can set aside that order. But if you're going to be giving direction, the supervisory jurisdiction of what the High Court has to a subordinate court, the Supreme Court does not have to the High Court. And now there is a judge, if the bench says that, and if there is Attorney General or the person of his eminence could say, what you're doing is not correct, he will modify. They immediately withdrew and backed out. We require men of eminence, just not in the judiciary, not amongst the judges. We require men of character and sterling abilities amongst the lawyers also. That is what is lacking.
Instead of saying issues on an isolated basis, if you see there is a thread, you take the case of, I was mentioning about Azan. Now you take Diwali crackers. Supreme Court came down saying air pollution, noise pollution, ban everything. And then they were bursting crackers in front of the Supreme Court in Tilak Marg. And the next year, Supreme Court says, fix a limit for making crackers. This is one way. If you take the Azan, in Allahabad High Court, there is a mosque. It has been there for 100 years. And then there is a call for prayer. Sometime on Friday afternoon it calls. Now some judge says you can't remove all this loudspeaker. Now this is start from the High Court campus. Now once there is a green signal, everybody now talks about Azan call. Remove the loudspeaker. We can't bear the noise, which they have been bearing for the last 4 centuries. Even after the loudspeaker is found, at least for a century they have been there. Now what do? You are now air pollution or sound pollution. Remove all of them. Now you use the existing law, try to stop some practice which has been there. All right. Now Yogi Adityanath removed 134,000 loudspeakers from various mosques in Allahabad. Now what he does is, we have removed so many things. Now what are you going to do with the loudspeaker? We will donate it to all the schools for public address system. So you rob Peter and pay Paul. Everybody fine. Now this is how it starts. The green signal comes from here, air pollution, within the Allahabad High Court. Now the entire UP remove every loudspeaker. Now issues which are non-issues till yesterday are made as issues. Now Karnataka experiment is a clear laboratory where not only state, there are private parties, there are private forces which dictate terms on issues which have never been there. Now try to use it. Now judiciary suddenly comes in. All right, discipline, you need to have uniform, school uniform. Therefore, there are 101 ways. What is now questioned is not what is the private group is doing, what the judiciary is doing, whether they realize they have a constitutional duty to protect the minority right. In fact, last month, Amartya Sen, speaking in Calcutta, he said, I find the Indian judiciary looking silent towards the fragmentation of this country on religious lines. That is a pain.
Today, an interesting case has been reported in some detail in the Hindu. It's called Framework Most Foul. Apart from where it was published, it raises certain questions. Komal Lodha, who was 17 at the time of the crime, went through a trial and was convicted of rape and murder of a girl child, a minor. And he was awarded the death sentence. The Sessions Court, later it was commuted to life by the High Court. And the conviction stayed, they appealed, and the Supreme Court upheld the conviction. Now, thanks to a public-spirited lawyer who appeared pro bono, they looked at the DNA evidence, and the High Court has now determined that the DNA evidence absolves Komal Lodha of this crime. Completely innocent man. But the Supreme Court has convicted him. The High Court has come out with his order and also ordered the police to reinvestigate the case, this case. But their hands are tied because they are restricted by the Supreme Court's conviction. So the matter will now go for review or an appeal for the Supreme Court. but it just shows what, what people go through, particularly when they are so poor and desperate. A farm laborer who has been and he was also a minor at the time of the conviction, but the court held that he was juvenile rather, but the court had held that he could be tried. So I think this presents one of the challenges before the judiciary, maybe an unusual case. Would anyone like to comment on it? Yeah, we're going to finish.
Yeah, I had a similar case like that, and where a spirited person brought a case to court to say that the person who has been convicted for rape of his daughter was not really the person. They were sons of two MLAs who were responsible. It turned out that they were the persons. Fresh trial was there, and a claim for compensation came through another writ petition. I passed an order directing 10 lakhs of compensation to be paid. And now the newspaper carried the report, and the reporter went to the village to find out what that man is doing. They found out the man is dead. He was not even there. The village family itself shifted out to yet another place. And by the time I passed an order, even before I passed the order, he had died. They had displaced themselves from that village to another village, because they couldn't stand the ignominy of finding that their father was convicted for murder, rape and murder of their daughter, of his daughter. The superintendent of police against whom I passed an order to pay 10 lakhs, he said, you have passed an order against a dead person, in favor of a dead person, it is therefore invalid. So that was how they wanted to short-circuit the whole thing and to render the order invalid. Then I said, in public law remedy, the case is never disposed of for that individual. It was for the family that was done. And it turned out that the family members were more aggrieved than the person himself. They had uprooted themselves to another family. Therefore, it has to be done. It keeps happening. It's just not in our country. Now, bite mark evidence as something which was credible, they were thinking for a long time, till it was busted by scientists and said, no, this is not correct at all. In 1 month, Operation Innocence in US brought about some 32 death sentences getting converted. It has happened in about 4 or 5 years back. So therefore, these kind of things happen. DNA provides extraordinary evidence. These kind of reversals, when they're happening, it's sound. And therefore, the good part of it is now the Supreme Court, as in a case going from Maharashtra, has said that if there is no DNA evidence produced, then the prosecution has not done its proper case. Therefore, we set aside the judgment. That is what they've done while acquitting, finding that DNA evidence was not produced. So the best of scientific evidence, a scientific temper, is what is necessary for the courts. And that, if it happens, I'm sure the innocent persons, like how there was a miscarriage of justice, there is bound to be a reversal. I'm sure if review, I'm sure, at least a hope that things will work better.
At that time, I was going to ask about this phrase called constitutional morality, which Dr. Ambedkar raised in the Constituent Assembly debates. But I don't think there's time. But in case somebody wants to, one of our 3 distinguished former judges want to say something on it, even if briefly, that would be useful. But it's up to them. Justice Chalameshwar, please give. Let him come.
This expression, constitutional morality, well, I can only give a parallel. 1974, I think, 74 or 75 year, I don't remember, delivering the annual lecture on the budget, late Mr. Palkhiwala opened the speech, the statement, for the benefit of the youngsters, I'll tell you, 1970s were the height of socialism, socialistic talk in this country. So Mr. Palkhiwala opened his speech saying, socialism in this country means many things to many people. For some, it simply means a berth in the cabinet, he said. So this constitutional morality, it all depends on who is using this word. Forget about the constitutional morality part of it. A constitutional, well, of course, once again, it's a phrase, it's an expression. It's a philosophy. What exactly do we do we understand by the Constitution and the scheme of the Constitution is the question. You call it the constitutional philosophy or constitutional morality, whatever tag you give it. But like many, many undefined expressions in law, these undefined expressions, when they pertain to the constitutional document, create greater problems. Those who are using this expression, constitutional morality, must first define what they mean by it. The constitutional morality of a particular political party may not be the same as the constitutional morality of another particular political party. The constitutional morality of a particular judge, Supreme Court judge, may not be the same as his own colleague on the bench. So therefore, these are all very nebulous expressions. The better thing is to go by the text of the document. If there is any difficulty in understanding the text, because necessarily the text must be understood after examining the scheme of any legal document, more particularly Constitution. In the context of Constitution, what is more important is to know the historical background of the document, why a particular provision was introduced, why a particular set of provisions were put there in the Constitution, what is the purpose sought to be achieved. Well, you call it constitutional morality, perhaps that's how I look at the constitutional morality, as he was saying, Mr. Ram was saying. It all depends, Mr. Chandra was saying, the parchment. In fact, I use that expression, of course I borrowed, it's not my own, I borrowed from somebody else. So don't look at the Constitution as a document written on paper with ink. If you look at it as a document written with the blood of the Jallianwala Bagh martyrs, it makes a different sense altogether.